Hello, I'm Mike Flanagan, partner and co-chair of Foley and Lardner's Food and Beverage Industry team. I'd like to welcome you to our Newsfeed webinar, When Food Safety Collides with Employees' Legal Rights. Today, our panelists will discuss labor and employment issues that food and beverage companies face stemming from conflicts between food safety and employee and applicant rights, and they'll be suggesting some solutions to those conflicting obligations. Let me briefly introduce the presenters that you'll be hearing from today. Bernard Bud Bobber is a partner in Foley's Milwaukee office and is a member of our food and beverage industry team, and he's the vice chair of the firm's labor and employment practice. Bud spends the bulk of his practice representing manufacturers, suppliers, and retailers in the food and beverage industry on a full range of employment and labor law issues, including defense of employment discrimination and wage hour claims, labor relations strategy, contract negotiations, labor arbitration, and employee benefits litigation. Bud has obtained dismissals of dozens of employment discrimination claims and has obtained well over 100 favorable labor arbitration awards for food industry clients. Dabney Ware is of counsel and a litigation lawyer in Foley's Jacksonville, Florida office. Dabney is a member of our labor and employment practice and our food and beverage industry team. Dabney has extensive experience both in employment-related litigation and in counseling clients on all aspects of compliance with the myriad of federal, state, and local laws. Dabney does significant counseling regarding wage and hour, harassment and discrimination, employee counseling and discipline, and workforce reductions. Ryan Parsons is a litigation lawyer and a member of Foley's labor and employment practice and our food and beverage industry team. Ryan has represented food manufacturers in numerous labor and employment matters before state and federal administrative agencies and state and federal courts. Prior to joining Foley, Ryan served as a law clerk for the Honorable Diane Sykes, U.S. 7th Circuit Court of Appeals. Before we start, I'd like to go over just a couple housekeeping tips. Today's program will run for 60 minutes. We'll apply for one general CLE credit for today's program. All New York and New Jersey and Kansas attendees applying for CLE credit must fill out an attorney affirmation form and write down the course code that will be given during today's web conference. Electronic questions can be submitted throughout the broadcast by clicking on the Q&A tab at the bottom of your screen. Now, I'd like to turn the program over to Bud Bobber.
Thanks, Mike. Hello, everybody. As you heard from Mike, both Dabney and Ryan, as well as I, are members of our labor and employment group. We're labor and employment lawyers that have had the opportunity to do a lot of work with food industry clients. And we thought it might be useful to highlight in a session like this what we see as some of the recurring labor and employment challenges for all types of employers that seem to be particularly recurring or acute for food companies, often because of the nature of your business. You're different than a widget manufacturer or seller because it is food, and food quality and food safety is reigns supreme in terms of the business's obligations and interests, and sometimes those are in tension with the rights of your employees. And so we put some thought into trying to identify the major categories of labor and employment issues where we saw that happen with our clients. The category that we divided up and assigned to me to address at the outset is wage and hour. All employers should continue to focus on wage and hour issues because they're not going away yet. It's been a trend in court litigation for the last 8 or 10 years that wage and hour lawsuits continue to proliferate. To give you a couple of statistics, we know from the federal court data that in 2014, Fair Labor Standards Act lawsuits were up again in 2014, just 2.5% in 2014, but on the heels of a 2013 in which filings were up 11.7%. And That doesn't even reference state law wage claims, and a lot of plaintiffs' lawyers do prefer to file their wage and hour claims in state court where they can use class action procedures compared to the Fair Labor Standards Act, which has the so-called collective action procedure. The difference is in those state court class actions, typically, everybody in the defined group is a member of the class unless they file a paper with the court that says they'd like to opt out. And typically, when employees get a notice of a lawsuit that says, hey, you might recover some money, would you like to opt out? Typically, employees don't rush to opt out, and those state court class action cases then end up with more claimants in the mix. The opposite is true of the Fair Labor Standards Act lawsuits. Those collective action procedures require, during the course of the pretrial process, require employees who receive a notice of the lawsuit to actually file a piece of paper that says, yes, I want to opt in. Please include me. And opt-in rates continue to run in the range of 25 to 30% of the potential class of claimants in a wage hour case tend to opt in. And so you could imagine from a plaintiff's lawyer's perspective, where they're trying to score the biggest judgment or settlement or remedy, which drives the largest attorney's fee award, they prefer the state court procedures. And so when you consider that there's as many or more state court class actions being filed as the federal FLSA collective actions, you realize that this is a very active area for employment litigation. And, you know, many of our employers are concerned about these kinds of liabilities, not only because you might have to write a check if you have a wage and hour liability, but it really implicates employee relations issues and social justice concerns. More and more, the plaintiffs' lawyers talk about wage claims as wage theft, and they demonize employers for stealing, you know, the wages owed to their hardworking employees. And typically, food companies are appropriately sensitive to those reputational issues. You know, after all, you need the marketplace to continue to respect the high integrity of your business and the trustworthiness of your product, and things like publicity about stealing wages from your employees undermines that. Just a reminder for everybody, when you talk about your exposure on a wage and hour claim, at least under the Fair Labor Standards Act, a plaintiff who wins on a claim that they were owed additional wages, overtime or minimum wage, they can get their back pay, and typically for a time period dating back 3 years from the time that the court case was filed. If you continued the same practice that they're challenging during the lawsuit, the back pay continues until there's a judgment in the case. So sometimes that could even be another year or year and a half or 2 years after the filing. The FLSA allows for the damages to be doubled. That's the so-called liquidated damages. And then, of course, like most employment statutes, a prevailing plaintiff wins their attorney's fees. Along the way, you probably tried to defend yourself and pay defense lawyers, so the company also has its own costs for defense. And so it's pretty easy to see how a very simple wage claim adds up to real money that the business would care about. I won't waste too much time on this simple example, but it just by way of showing that if you had a claim by 50 employees who said that they were required to, as a matter of your company's practice, appear at their workstation 10 minutes before the scheduled start of their shift, just to do a handoff, for example, with the employee leaving from the prior shift, their predecessor, basically. And those handoff meetings weren't paid, but they essentially were required by company practice. And you got a lawsuit about that. You could see how even 10 minutes of pay for as small a group as 50 workers can add up into six-figure liability. And I made some estimates about defense and consultant costs, but it's a $500,000 issue pretty easily, and much more if you're talking about more people, more time, higher average wages, or longer time periods. It could be that, in addition to the 3-year look-back period from the filing of the complaint, that the practice continued for another year during the course of the lawsuit. And so these six-figure liabilities can pretty easily become seven-figure liabilities on wage and hour cases, and the plaintiff's lawyers like them because of the fee shifting. I want to mention the increasingly common Fair Labor Standards Act claims that we see and food manufacturers see. Many of them are for off-the-clock work, and it's important for employers to think about and really self-audit in a way whether or not you have any practices where people are required, hourly employees are required to engage in some kind of work-related task, but it's not on their paid time. And I just gave the example a minute ago. What if they're required to do a shift handoff discussion before the start of their shift, and that's not captured on the paid time somehow by the way that you track time? You'd be exposed to an off-the-clock claim. We still see claims for missed meal and rest breaks. That's largely a state law issue because the federal law says that you can have a bona fide unpaid meal period if it's 30 minutes, and some argument about 20 minutes, but that's not entirely clear. And employers get themselves in trouble on mandatory unpaid meal periods where their system is set up to do an automatic deduction of 30 minutes from everybody's daily pay. And, you can defend that if you have proper controls in place, like notices to employees about you're not supposed to work during that time, and some training for your supervisors about don't require people to work during their unpaid 30-minute meal period. Or if you do, put an exception into the system to make sure they get paid for it. We still see a lot of misclassification cases. In the food industry, I see the misclassification claims relating to lead workers who might not be true supervisors with the authority to hire and fire, but they're foremen, basically, who direct other workers, and sometimes employers are a little too aggressive in treating them as exempt from overtime. The same is sometimes true with QA personnel who might not have the supervisory responsibilities, and the lower QA personnel might not have a college degree requirement type of thing that could make them appropriate for the professional exemption. So those are worth keeping an eye on. More and more, we're seeing these class action wage and hour cases brought on behalf of unpaid interns and independent contractors who allege that I really wasn't an independent contractor. In essence, I was an employee, and I worked 50 hours a week, so you owe me overtime. So beware of those and be diligent about your independent contractor designation. But the granddaddy of them all for food manufacturers in recent years has been wage and hour claims that are called donning and doffing claims. And if you haven't heard this, essentially what it is, donning is the act of putting on some clothing, like, don a baseball cap or something like that. Doffing is the opposite. It's taking it off. And so these cases are all about plaintiffs claiming, employees claiming that they should be paid for the time that they put on the uniform or other work clothes or protective gear, earplugs, hairnet, safety glasses, bump cap, on the front end of the shift and on the back end of the shift. And employers need to know that what gets implicated in these claims is the travel time from the locker room where people might put on the clothes and the gear out to their workstation in your production facility. Typically, walking over to the workstation from the beginning of the shift, you enter the facility and you walk over to your workstation, that typically is not paid time. But if there's donning time, changing time up in the front end of the facility in a locker room, for example, then that gets treated as compensable activity. Then it basically ropes in or brings in with it the subsequent time it takes the employee to walk from the locker room to the workstation. And that all flows from a Supreme Court case in 2005 that basically put this donning and doffing issue back on the map, brought it to the attention of plaintiffs' lawyers, and started the explosion of this litigation. So let me give you a few guiding principles. I mean, what's going on here is the assessment of whether these clothes changing and gear changing activities are work. And that's because the Fair Labor Standards Act and state laws say employers have to pay for all hours worked. And under the Fair Labor Standards Act, typically that means activities that are integral and indispensable to the primary job duties. If it's closely connected to the primary job duties, it may also be work, just like the core job duties are. And, you know, employers don't win the argument that it's really not hard to put on a hairnet, so why should we pay for that? Minimal effort doesn't really matter. And the argument that it's really a small amount of time, so why should we care about it? That may not matter anymore anyway, either. Just last year, we had a Supreme Court decision in a donning and doffing case, and many employment litigators conclude that the so-called de minimis doctrine of disregarding small amounts of work time is really under question as to whether or not that's a viable defense for employers anymore. Most recently, you might have seen, though, although not a food industry case, the Supreme Court just ruled in a case called Integrity Staffing Solutions that employee waiting time at the end of a shift to go through a security screening procedure was not compensable work time. It wasn't integral and indispensable to the performance of their core work duties, and therefore did not have to be treated as compensable work. That was a case that arose out of an Amazon distribution facility, and the employer required the employees to go through a security screening check at the back end of the shift to make sure that people weren't walking out of the facility with products. And that could happen as well in a food manufacturing company, and it's an interesting new ruling and tool for employers to use. So I need to move quickly through my last few screens here. On donning and doffing, a real important aspect of the determination of whether it's going to be compensable is whether the employer requires that this be done at the work site. And here's really where food safety is a challenge. Many employers want to require employees to change into clean uniforms and clean shoes at the workplace, so-called captive shoes, captive clothes, and that's all to the benefit of your GMPs and your food safety. But if you're required on the work site, more likely that it's compensable. You know, a lot of fast food entities, for example, require people to wear uniforms, but they can put them on at home. And if they put them on at home, it's likely not compensable. They needed to put on some clothes to go from home to work, and the courts won't find that to be compensable in the same way as if you're required at the work site. Also, the issue of whether the requirements of clothing and gear, is it primarily for the benefit of the employer or the employee? That becomes a relevant consideration in determining whether it's compensable work. But when we're talking to food manufacturers and we're talking about clean clothes, clean shoes, and protective gear, typically courts would agree with plaintiffs that that's primarily for the benefit of the employer. So a few tips to try to manage this potential exposure if you're having people change into clothes or gear outside of paid time. Make sure that your workforce knows what's mandatory or optional. You don't have to pay for optional things. You might provide an extra sweatshirt for people that have to go into the cooler, but you don't make them put it on. It's their choice, and you should be clear in some SOP or some other writing what's optional, because typically you don't have to pay for optional changing. you got to think about ways in which you can minimize how much time people spend on mandatory changing. Maybe at the end of a shift, you don't need them to change out of their work uniform. Maybe you can allow them to take it home and bring it back the next day, throw it in the laundry bin the next day for your professional cleaning, if that's your practice, and that would at least minimize some downside on the changing time. I know of some employers that got away from uniforms in pants and shirts and just required a clean smock be put on by its food manufacturing employees. That really minimizes the time that people have to spend. They can walk in, pull a smock off a rack on their way into the facility, and that really should be nothing more than 10 seconds of time. Same thing with shoes, and I've seen some employers go to the point where they just expressly prohibit any pre-shift changing into uniforms or gear. The last thing I should say about this is if you have a union in your facility that represents your hourly production employees, the other issue is the Fair Labor Standards Act CBA exemption. This is Section 2030 of the Fair Labor Standards Act. And in the Donning and Doffing case last year ruled on by the Supreme Court in a 9-0 decision gave employers a victory and said that this exemption applies to even the gear changing if gear and clothes changing is done basically at the same time, uniform clothes and then some earplugs and safety glasses, so long as the bulk of the time is spent on the clothes changing. Basically, the Supreme Court applied a broad view of the exemption, and the exemption says that where there's a union in place, the issue of whether the clothes changing time and hand washing time is going to be treated as compensable is governed by the labor contract, or if it's not stated in the labor contract, any customer practice that exists in a labor relationship. This is a great tool to manage federal law liability for donning and doffing claims, but employers beware that plaintiffs' lawyers are creative and clever, and many of them are suing under state laws and asking state courts to ignore the CBA exemption of federal law and to rule that under state law, the employer owes wages for the donning and doffing time anyway, regardless of what the CBA says. That theory has been rejected in some cases in Illinois and Missouri, but it got traction in a case in Wisconsin, and it's percolating elsewhere across the country. And so with that, I'll conclude on wage and hour. Mike, shall I pass off to Dabney?
Yes, why don't we do that at this point? And we'll deal with questions later.
All right, everybody. I am going to talk just generally about concerns that may arise in manufacturing facility that really, just to be a little bit simple about how we're calling it, deal with either employee illnesses or other conditions. And so I wanted to kind of talk about just some of the overarching themes and what may be in play. And frankly, this gets pretty complicated, so I don't think we're going to be able to really fully explore all of the factors that may come into play. We're going to concentrate on the Family and Medical Leave Act and the Americans with Disabilities Act. But there can be company or local issues. The company policies are going to play a part in this. Company benefits, there's collective bargaining agreement, it's workers' comp is at issue, mandatory benefits, all of those things may be in play. So I don't want to oversimplify this, but I want to kind of hit the big themes. And here are some general considerations, and this, I think, reflects kind of a changing landscape, particularly with ADA, but some other employment issues as well. It used to be that I think a number of folks who had to deal with the employment issues felt as though they were relatively safe if they were being consistent. And that's just not necessarily the appropriate paradigm anymore. The ADA imposes, for instance, a need for individual analysis. So there's some level for a need of consistency, but there's also you can't have blanket rules, and you can't necessarily have consistency as the goal if individual analysis is required. So you may have two employees with similar conditions, take diabetes for instance, but the way the symptoms manifest are very different, and therefore the outcomes or the consequences could be very different. One of the things to keep in mind is that your common sense does not trump the opinion of a medical provider. So we just have to be careful. It may be that there are some questions that are arising or things that don't make sense. That may form the basis of getting a second medical opinion, and depending on how that goes, perhaps a third. But we all need to make sure we're never in the position of substituting our common sense, judgment based on experience, for essentially what a medical provider has stated. That being said, this is one of the tricky things, I think, is that you really still are on the hook to use your common sense. So you have to keep in mind and evaluate things based on what the circumstances require, but you can't rely on anything that may be stereotyping or paternalistic. And we've got a couple slides in here about pregnancy, and that's kind of a good example. So talk about that a little bit more later. In general, what I'm trying to do when I counsel clients is I'm trying to minimize the legal risk while I'm trying to achieve the business objective. So I say that because sometimes there are things that I think really have a big impact in lowering the legal risk. They really don't set the business back. They're not hard to do. They're not costly. And if there's a big upside in decreasing the risk, I'm going to advocate for that. And I think that's just a good decision matrix. Then finally on this slide, one of the things I think it's important to keep in mind is that there are just differing policy goals. So if you sometimes feel like these things are in conflict or there's a tension, I think you're right. When we talk about the family and medical leave, the basic thrust is to protect the employee's right to be away from work. We're talking about the ADA. It's to help the employee stay at work. And then workers' comp, we're not going to spend a lot of time on, but what gets lost in translation, as frustrating it is as it is for employers these days, is that the public policy for the most part behind workers' comp was essentially to trade a bunch of liability suits based in negligence for which you as the employer might have to defend yourselves. You were going to get automatic liability, but it's limited. So there aren't these huge negligence suits that tended to exist before workers' comp. So let me just kind of quickly walk through some things. I've got a bunch of hypotheticals and a bunch of other things, and probably not enough to really cover it in a whole lot of detail, but I want to just talk about a little bit of the paradigm about what may happen. We've got a supervisor, they're walking through the production area, and there's a line employee who's coughing, not just, but, big coughing or coughing a lot. What do? There are a couple of things. Again, this is where common sense is in play. You ask and confirm the status. Are you coughing? Is there a problem? Are you sick? Is there something going on? If it's questionable and they're in a position that could impact food safety, you've got an option to send them home. This may be where consistency is in play. Depending on what the information they've given you about the basis for the coughing, you may need to alert HR to a need for leave. And then there may be the need to require a fitness for duty exam to return to work. Those are basic things, but they're not always that easy to apply when it comes down to it. And here are just a couple things I was thinking about. Would it make a difference if you're essentially the facility or the community is in the midst of a flu outbreak? Probably does. You may have heightened sensitivity. You may be very sensitive to somebody showing the flu symptoms. And you may be very essentially aggressive in trying to get those people out of the facility, both in order to avoid any food contamination and contamination of your workforce. That would be permissible. Are you going to implicate family and medical leave? Maybe. It would have to meet the definitions of a serious health condition. We're not going to cover that today, but certainly if it's serious enough, it could. But that's going to essentially protect the employee's right to be away from work. What if the employee was out last week to take care of a sick child and they've exhausted their paid leave? You've got some practical considerations there. maybe it's more likely the employee is sick because they spent time with the sick child. There also may be the tendency to talk about, I'm out of my paid leave. I can't afford to not be here. So some of these things you need to have thought through in advance and make sure that you understand what your organizational kind of tone and tenor is to deal with these things. Whether it's going to be aggressive, how much are you going to wiggle room are you going to give employees, what are you going to do? Final one here is to talk about, what if the employee says he or she has emphysema? And the point there is that emphysema tends to be a chronic but not necessarily a contagious disease. So that may implicate both considerations either under family and medical leave in terms of time away from work, depending on what their symptoms are and how it impacts them, or there could be some issues under ADA. What if the coughing is due to environmental issues? And again, just kind of throwing out a few ideas. There could be a lot of things. Somebody can have trouble with food particles. Maybe it's dust. Maybe it's you have a new cleaning company or you're using a new cleaning solvent. All of a sudden, that's a problem. So, there are a lot of things that can be in play here. And I think this is where we have to put on our common sense and understand what really is taking place. Is it an ADA issue? Well, if it's an irritated cough, there may be no family and medical leave issue and no ADA issue. On the other hand, if the employee is claiming that it's something chronic for which ADA may be in play, you do have the ability to seek medical confirmation either of the condition or the limitation. One of the questions I think is important to think about in this context is, do you assume it's a covered disability? A lot of times as a practical matter, we don't really know if it's going to be a disability as defined or covered by the statute until you're well into litigation. You've got a lot of medical records. You may need experts. So sometimes it's very obvious. Sometimes it's obvious it's not a disability, but most of the cases really fall in between. And so often I don't think trying to identify whether a disability is at issue is actually the best first step. Usually what makes more sense is to understand what reasonable accommodation is being requested. And if that's relatively easy, it may just make sense to provide it. You don't have to necessarily admit or concede that there's a disability at issue as covered by the statute. But if it's easy enough to make a change that the employee's requested, that may be appropriate. In other cases, you're going to want to know more. And you may need, just going back to the coughing example, you may need to understand what's the cause of the irritation. If it's, an environmental allergy that's both outside and inside the building, may not be able to do anything for it, may ultimately not be a situation that can continue. It's going to depend on how serious it is. Medical certification, I've given you here just a little bit of information. The ADA limits the medical inquiries to the disability, and the inquiries need to be job-related and focused on whether or not the person is able to perform the job or what changes might allow them to perform the job. If we're talking about family and medical leave, you can also request a medical certification, and you can get certification typically every 30 days, but sometimes it's after the initial certification expires. So you just need to make sure you're following the regulations and understanding all the components of that. So here's another, this is kind of my pregnancy example. What if you've got an employee, they're mixing ingredients, employee says she's feeling faint, she thinks it's related to her pregnancy and she needs to go home. Well, the options are basically similar to before. You need to kind of understand what the status is. Certainly they've requested to go home. If that's not a problem under your policy, they can be allowed to go home. We don't really know what's going on with the fainting, so you can't make judgments about what that is or what it's not. Maybe a need for possible leave. And again, depending on what's taking place, may need to be an opportunity to have fitness for duty certification before returning to work. But what you have to do is avoid being paternalistic. And another example where pregnancy is concerned is sometimes people in their common sense experience of either their own pregnancy or people they've known to be pregnant will say, well, at some point this is going to affect the ability to lift when you're pregnant. But you can't assume that that's going to be a problem for the employee. You can't assume it's a problem early in the pregnancy. You have to wait and essentially let that play out. If you're going to impose changes in the job duties based on an anticipated restriction of lifting, that's going to be a problem. That could give rise to a pregnancy or disability claim. That's what I would consider to be paternalistic. On the other hand, I think you've got to be sensitive. If you've got a pregnant employee and you need to use your common sense and you see them going to lift something and they're struggling, you may want to ask if they're having a difficulty, if they need some help with that. Have they talked to their doctor about the job requirements? All of those things would be okay, but it's a step short of assuming that the employee can or cannot do something. What if somebody passes out and says she might be pregnant? At that point, I think the pregnancy kind of comes out of the equation, and you're going to treat them in a similar manner as you would any employee who passed out. So you want to understand what the cause of that is. You want to understand if it's likely to happen again, what else may be taking place. If you've got a diabetic employee who passes out because of blood sugar issues, one of the things that may be a reasonable accommodation is to allow breaks for snacks. But depending on the production requirements or if the needs or the breaks are too frequent or the incidents are too severe, it may not be a reasonable accommodation, or they may not be an individual who's protected by the Act. Those choices are risky and they are difficult, so you kind of want to be patient as you reach those decision points. Just to kind of reiterate, there was new pregnancy guidance that was passed in July of last year. The EEOC is focused on pregnancy as one of the ways that it really wants to focus its litigation efforts and its resources, and we're seeing some of this bubble up through litigation. The Supreme Court recently had a case, Young versus UPS, that addressed one of the points in the guidance, and that was a lot of companies used to have a distinction between essentially at-work injuries and not-at-work injuries with regards to the availability of light duty, and saying we're not treating pregnant employees any differently. We're treating pregnant employees in a way that's consistent with how we treat all not-work injuries, and we're not going to make light duty available. The EEOC guidance is contrary to that. That's currently what exists, but the Supreme Court has taken up this case, and we're waiting to hear what the result is. The pregnancy-related accommodations that are mentioned in the guidance should not be a surprise. They're very similar to what you might have under the ADA. It talks about redistributing marginal functions, modifying how job functions are done, modifying workplace policies, purchasing equipment, modifying work schedules, granting leave, temporary assignment to a light-duty position. So all that analysis is essentially similar to what you're probably already doing in other circumstances. Again, this is just a little bit clarification of how reassignment and light duty look under some of the common paradigms. Family, you can't force someone to accept light duty, but you can temporarily reassign them as long as it's to a job that has essentially the same pay and benefits. Workers' comp typically is going to promote light duty for workers' comp injuries, and if the employee refuses, will result in the loss of their benefits. ADA, you're not required to create a position. It can be a little bit fact-specific, so don't just assume that's the bottom line for all situations. But it may be that you provide a change on a temporary basis without creating an obligation to do it. If that's the case, you want to make sure that you're doing it on a temporary basis and you've communicated that. So there are, this is just another hypothetical, maybe something that comes up with you see an employee having difficulty with focus, their ability to pay attention, and at a meeting with the supervisor, the employee says she has a drinking problem and is being treated for depression. It may be eligible for rehab under family and medical leave, and under the ADA, alcoholism may or may not be a disability. Again, kind of fact-specific. Depression likely is. if focused tasks are likely an essential function, it may be an accommodation to provide leave for treatment or temporary reassignment if they're in rehab and can do some other things. Those issues are pretty difficult, and they're not at all easy, and I like to think that one of the things you have that's not a legal tool, but is to make sure supervisors and people who are in decision positions understand that patience can be a weapon to help create the facts, and it should be used aggressively. And in these cases, sometimes patience and being passive may look outwardly the same, but they are very different. So trying to be patient and get to the right set of facts can be very helpful. Just a couple more things, but if the employee says she wants to keep working, current job is too stressful, you've still got family and ADA in play, but you may want to understand what the employee is seeking to address the complications and understand that. Changing a supervisor, if they're attributing the stress to the supervisor, is not normally going to be a reasonable accommodation. Leave to kind of get some therapy, get their own emotional stability back, maybe. And then this final bullet point is just talking about what if you've got good documentation and you're coming into the meeting, you the employer, thinking you're going to terminate employment, and in the middle of that, the employee requests leave before you get the words termination out of your mouth. It's a mixed bag. In theory, if you've already made the decision to terminate, it's not going to be related to the request for leave. But I would really hesitate to want to have to take that battle on if we didn't have to, especially if it's a good long-term employee. But the circumstances and the history of what may have taken place before, including discipline documentation and other things, I think is really important there. It's just that's a situation where when we talk about minimizing the risk and maximizing the business objective, I think there's a lot of tension between those two things. So we'll skip this other one, just talking about a seafood allergy. And there are just a couple of takeaways. Wanted to talk about you can't get medical opinions. It's important to understand that's a tool in your arsenal. And just because someone is entitled to leave, you can restore them to a former position, but it essentially has to be the same. There's a high standard for what is equivalent. And at the end of a family leave, their reinstatement rights cease, but ADA may come into play. So very quickly, just a couple things under the ADA. Employee is required to inform you they need an accommodation, but they don't have to use that magic language. You can request documentation unless it's obvious. If there's more than one accommodation that will be effective, you can choose what's easiest for you as the employer. Reassignment to a vacant position may be a reasonable accommodation if the person is qualified. If it's a higher level, you can require the employee to compete. If it's the same or lower level, you're generally going to be responsible to plug that person in. And whether or not a position is considered vacant, not always that easy. As the employer, you may have kind of advanced knowledge, and the EEOC is going to hold you to that. So if you know it's coming available, that would be something that the EEOC needs to be taken into account. You're not required to have bumping in general unless that would otherwise be required somewhere else, but the ADA itself doesn't require it. And again, as I said, changing a supervisor is not a reasonable accommodation. So you can move someone to part-time. You're not required to lower production standards. And if you provide leave, the assumption from the EEOC's perspective is that it's going to be job protective leave. So if that's not what you're doing, you need to be clear. And again, it can be a little bit risky, so you want to think through that a little bit more. Make sure you're getting good advice and you're considering all the circumstances. Things that are going to disrupt a production schedule, probably not a reasonable accommodation because it creates an undue hardship. But determining what's an undue hardship can be a little bit difficult. Just a few kind of final thoughts on that is that undue hardship is not limited to financial difficulty, and the EEOC sets a high standard. We don't always agree with the EEOC guidance, but it's the starting point. So if you're going to depart from what we would think their evaluation is, you want to make sure you're doing it very knowingly. And they're going to evaluate undue hardship by the net cost to the employer. So if there are tax advantages or other things that come into play, that's part of what needs to be considered. And finally, one of the things that I think is most difficult for employers is that just having a morale problem for other employees is not going to be considered an undue hardship. But if it's disrupting the ability of other people to work, it will be. And with that, I'm going to turn it over to Ryan.
Thank you, Dabney. We'd like to leave a few minutes at the end for questions, so I will be moving relatively quickly through these slides. I think the first key takeaway here is, more than ever before, labor law issues apply to both union and non-union employers. For a long time, employers essentially who did not have unions thought that they could ignore these labor law issues, and with the current iteration of President Obama's NLRB, that's no longer the case. Just some quick background on that. As you probably know, union membership, especially in the private sector, has fallen pretty precipitously over the last generation. We're now down to just 11% of all employees and just 7% of private sector employees as union members. So one of the things you see is the National Labor Relations Board, which is ostensibly supposed to be a referee, becomes more of a pro-union advocate. The president gets to nominate and appoint the majority of the NLRB. So when you see a Republican in the White House, it tends to be pretty pro-management. But now, of course, when you have a Democrat in the White House, it's very pro-labor. And so here you see some of the steps that the board has taken in recent years in that pro-labor direction. The newest one, which we won't talk about in detail today, is quickie elections, which really limit an employer's ability to essentially campaign if a union election is coming. If the employer is unaware of union agitating and receives a petition for an election and doesn't know about it, in the past they were able to push the election back, I think, about a month and a half, and which gives it time to essentially campaign and tell employees why they don't need a union. But now, under these new rules, the election is going to be held within 20 days of the petition being filed, so there's much less of an opportunity to engage in advocacy once the petition comes. So as a result, obviously the employer has a stronger interest in avoiding union issues before they arise. Another one of the big issues that's coming up here is what we call microunits, smaller and smaller bargaining units of employees. Historically, in food manufacturing plants, what we saw, the traditional presumptively appropriate bargaining unit was all production and maintenance employees. So everybody on the line, everybody working on the machines. Maybe you exclude quality people, maybe you exclude janitors, but generally anyone working to make the food or fix the machines is going to be part of one unit. But to do that, you need a majority support in that very large unit. And as unions have found that harder and harder to come by in recent years, they've gotten creative in selecting smaller and smaller units to try to organize. So you'll see specific, instead of production and maintenance people, you'll see just a maintenance department unit, for example, or potentially just the quality staff. More recently, this is not a food example, but we saw a union try to organize in a department store a unit of all women's shoe sales employees. So a really narrowly targeted group of employees within a much broader workforce, because the union knows that they can get the majority support of 2 out of these 3 employees or 3 out of these 5 employees, and they don't have to get support of 51 out of these 100 employees. And the board has actually blessed this approach. They developed a new test a couple of years ago in the specialty healthcare case, saying that unless employees excluded from the unit share an overwhelming community of interest with employees in the selected unit is going to be appropriate. So in this case, unless you can show that the production employees share an overwhelming community of interest with the maintenance employees, if the union wants a maintenance unit, it's likely going to be approved. So what are the takeaways for employers here? Ideally, you want to show that as many of your employees as possible share an overwhelming community of interest with one another. And so there are a number of steps that employers can take to do that. One is to take a look at your organization charts. Separate supervision is a very important factor in allowing separate units. So if the maintenance employees report to a maintenance supervisor and then a maintenance manager, and then up to the plant manager without any kind of common supervision with the production employees, it's going to be very difficult to argue that these 2 sets of employees share an overwhelming community of interest. Similarly, you want to have policies be as uniform as possible. So you don't want policies that apply to one set of employees that don't apply to other sets of employees, because then again that suggests that there's not this strong community of interest, that they really are separate, divisible groups of employees, and there's no reason for them to need to be in the same bargaining unit. And then the third step would be to try to find ways to allow employees to cross departments when at all possible, whether that's on a temporary basis, covering a maintenance employee, covering a production employee's shift, for example, or on a more permanent basis, allowing production employees to transfer into the maintenance department. Certainly, maintenance employees will generally have more training, but if you can offer the internal training opportunities to allow these employees to cross over between groups, again, you can kind of blur the lines between these two departments, make it much less likely that you're going to be susceptible to organization of this very small unit of your workforce. And of course, the reason you want to avoid that is the unions are attempting these micro units in an effort to kind of get their foot in the door, to represent some small set of the employees with the hopes that then they'll convince much larger groups to join the union or form their own union. So obviously there's a strong interest in avoiding that. So to the extent that you can make employees very similar, that's certainly in your interest. The other reason that non-union employers need to pay more attention to the NLRB these days is because they've become much more aggressive in policing policies in non-union workplaces. You've even heard it, instead of being called the National Labor Relations Board, you hear it called the Non-Union Labor Relations Board. The underlying principle behind this is that an employee's rights under the National Labor Relations Act are the same whether they're in a union or not, and specifically their right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. That right is the same regardless of whether or not you're in a union, and the NLRB has interpreted that underlying language extremely broadly. And what they've done is they've taken employers' general policies that have nothing to do with organizing, nothing to do with unions, and said, well, can this be read to chill an employee's rights? Can this be read in a way that an employee would say, well, I can't then talk about my wages with my coworkers? And they've done that more and more in recent years. For food manufacturers, there's a couple policies that I'd like to highlight. Excuse me, I just talked about this. One is kind of the social media policies along with non-disparagement policies. As Bud mentioned at the top of the hour, food manufacturers have a extremely strong interest in preserving their reputation for health, for quality, for cleanliness. And because of that, employers have a interest in keeping employees from spouting bad things about them. On the other hand, employees do have the rights to complain about the terms and conditions of employment to others. That's part of the Section 7 rights under the National Labor Relations Act. And that includes complaining on social media, on Facebook, on Twitter. The board has held that liking someone's post on Facebook can be a protected activity. Presumably, retweeting someone's tweet on Twitter is protected activity. So the question becomes, how do you balance your employer's interest in preserving your reputation with allowing employees to exercise their Section 7 rights? And one, I think, kind of broad way to do that is to consider adding very specific language to a social media policy or to an employee handbook, basically saying that this policy or this handbook is not intended to interfere with your NLRA rights. We're not going to interpret this handbook in a way that's going to impact your rights under the National Labor Relations Act. Anything in here that could be read that way, we're not going to interpret it that way. This is kind of safe harbor language that you're telling employees on the front end. You have the right to do what you want to do in terms of protected activity under the Act. What you don't have the right to do is, lie about the company, reveal confidential information about the company that's not related to your terms of employment. By including this kind of language, it's much more likely that the policy will pass muster with the NLRB, and more importantly, if you fire an employee, the employee is going to stay fired. Food manufacturers also have a strong interest in knowing who is on the facility at any given time. Again, Bud touched on the great lengths that we can often go to ensure the food is produced in a clean, safe manner, including hand washing, donning and doffing clothes, laundering clothes on site. So an employer has a strong interest in keeping employees off-site when they're on their shift. And such policies are lawful, but only if they're enforced very consistently, and if they're not done solely to stop pro-union activity. So the policy has to apply to all off-duty employees. You can't have a lot of exceptions. You have to enforce it consistently, and you have to enforce it not just when there's a union petition, for example. And you can only limit employees to going into the interior of the facility. You can't limit them from going into the parking lots. So that was a pretty quick overview of labor law, but with that, we have a couple minutes left, and I'll turn it back over to, I believe, Mike for some Q&A.
Thank you. Before we do the Q&A, CLE announcement. If you are in need of CLE credit today, please enter a 4-digit code into the poll question on the screen after it's announced and press the submit button. The actual code, though I don't believe it's showing on our screen right now, and we apologize for that, is UAOU. Again, U is an up, A is an apple, O is an orange, U is an up. If you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it to zrahim@foley.com immediately following the program. A copy of the form can be found in the resource list widget. Now, moving on to Q&A. We received a few questions by email. The first one relates to Bud, the donning and doffing presentation that you provided. The question is, if a group of employees in a department all have the same donning, doffing requirements, can there be a fixed amount of paid time per work shift be automatically added to this workday instead of having the employees actually punch in and out before and after?
And the practical answer is yes. If I'd be comfortable if a client did that after a reasonable assessment of the average amount of time that the donning takes. If it's based on a guess or an assessment of really how fast the fittest, most flexible, most agile of your employees could complete the task, you still may be vulnerable to a claim. Certainly there's folks that move slower than other folks just because of the nature of their body, their age, their arthritis, this, that, and the other thing. And so just adding a set amount of time is probably a safe practice if you always can document that what we did was we assessed it and set that set amount of time based on some actual observations of the amount of time that it takes a cross-section of our employees. But if you're just guessing and you may be under-guessing, then you could still be exposed to a claim by somebody who says, your guess of 5 minutes is wrong because I know every day it takes me 9, and so I'm suing you for the 4.
Okay. Dabney, one came in on your topic. What can we do if we know an employee is taking medication with possible side effects, such as drowsiness?
I think there are a couple things. This is where you've got to kind of balance this common sense analysis with understanding maybe what the legal obligations are. But, possible side effects don't mean there are side effects. If there's a medical facility on site or there's a nurse on site, one of the things you can do is defer to someone who can provide a medical opinion. One of the things to do is to balance maybe what the employee is saying. For instance, if somebody says, I routinely take Benadryl for allergies, even though drowsiness is a possible side effect, I'm not drowsy. If that's what they're representing and there's nothing to contradict that, I'm not sure I would make a big issue out of it. On the other hand, if they're behaving in a way that seems that is abnormal for them and is drowsy, then I think you're going to take different steps to kind of assess the impact of that medication. You may also distinguish, for instance, between over-the-counter prescription drugs, those types of things.
Good. Here's one that I suspect all of our panelists would have some thoughts on. But Ryan, it came out of your presentation. What should we do if we learn about employees discussing forming a union?
That's a good question, and certainly one we could spend many hours on. But to some degree, you're limited. It depends on what exactly you're hearing. Obviously, the best scenario is to treat your employees well and be upfront with them and make them feel that they can communicate their problems with you on the front end, so they don't feel like they need to have a union as a separate advocate or intermediary between you and the employees. But having said that, once you hear wind of a more formal organizing campaign, you are fairly limited in what you can do. The board is going to hold that now if all of a sudden you're going to give employees a raise after you hear that there might be unionizing, they may hold that as kind of an improper grant of benefit. If you obviously fire the employee who is talking about unionizing, that's going to be a threat, an attempt to coerce them from selecting a union. So you are fairly limited in what your options are. Having said that, sometimes the risks of a board violation in, for example, redressing employee grievances may be worth the price of a board finding that you violated something if you can really get on the employee's good side. So it's a complicated issue and one that you have to tread carefully on.
And Bud, donning and doffing seems to be garnering more interest, because another follow-up question came in on that. What if we tell employees not to change into their uniform clothes before the shift start time, but some of them simply choose to change clothes earlier so they're not rushed? Do we have a liability?
Yes, probably. So I'm assuming it's a facility that requires changing into uniform clothes, clean uniform clothes provided on site, and requires the changing to be done on site. The employer publishes some policy that says, don't change until you clock in and go on paid time. That's good. But of people that choose to get their changing done even before they stand in line at the time clock. They just don't want to be rushed, so they get their changing done, and then they maybe kibitz with coworkers or get a cup of coffee in the cafeteria, that kind of thing. I said probably still have a liability because of the nuance of the Fair Labor Standards Act that says employers have to pay for all hours worked, and hours worked means, you probably have heard this term before, any time that you suffer or permit an employee to engage in work activities. And suffer simply means you require them to do it, but permit means they're doing it and you let them. And so there's no volunteer defense to a good wage and hour claim, including in the area of donning and doffing. There's no successful defense that says, but we told him he didn't have to do it, and he just chose to do it for his own pleasure, convenience, or otherwise. We're probably still, as employer, exposed to the liability.
All right. Well, we are at the end of our hour, so it's time to wrap up our program. We invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. Thanks for joining us, and we'll be in touch with our next information on our next series of our webinars. Thank you, and have a good day.